Good evening, how's everybody doing? Great to be learning with you on a Monday. Let's light up the darkness. Welcome everybody. Paul in the Great Northwest, Sharon in New Jersey with her Havruta partner Sai the Talmud cat, Lucy in Minnesota, Bill in mid-Missouri, Bella in Florida, Tom says shalom, Melissa in Great Neck. Tom says hope everyone enjoyed your Chinese food and whatever movie you watched. We just had our Chinese food and we're going to the movies tonight. Sharon says, sorry, Sal, that my Eagles beat the Giants. I wasn't even watching, but I heard it was a pretty close and exciting game. Mazel tov, you guys came out on top. The better team won. What can I say? The Giants are a disappointment this year. Guy in Ohio, Shandor in the Bronx, Joseph in Lowell, Massachusetts, Joe in the Inland Empire, Aoife in Florida, Ella says Shalom Chaim in Florida. Welcome everybody. And to our friends who are celebrating the holiday today, we extend a big warm hug. Let's do some learning. Okay, so we're working our way through chapter 5 here in Tractate Bava, Kamma, the 21st volume of the Talmud. Now continuing our discussion of Mishna number 7. Which discusses this idea that there's partners in a pit and they left it uncovered. One had the opportunity to cover it. He didn't. Then the other one came and left it uncovered. Do they share liability? Is it only the second one who has liability? When exactly does the transfer of liability happen? These are the kinds of issues that we're dealing with. We start a slightly new subject here at the very bottom of page 52b. So the Mishnah teaches if a man was digging or widening a pit and an ox passing by fell forward into it in fright due to the sound of the digging, so he is liable. If it fell backward into the pit due to the sound of the digging, he is exempt. So Rav says the term forward means literally forward and the term backward means literally backward. And as we'll see, there's another view that backward means it didn't fall into the pit, it fell behind the pit, right? So it just fell, it was startled by a noise, and it fell. The only thing that the pit has to do with is that there's actually a guy in the pit digging it. And the sound, I mean, it's funny that they talked about the sound of a guy digging could startle an ox, maybe because the ox just didn't see him and then, heard something and stumbled. But they didn't have jackhammers back then, right? So I think all the more you could imagine that if the construction workers are using a jackhammer or a leaf blower, I don't know how many of you guys live in neighborhoods where the leaf blowers come out way too early. Or it's not even that they're so early, but often I'm recording videos here, either in the office or in the backyard, and man, those leaf blowers drive me bananas. Okay, but one view is, okay, so the guy was digging, and the ox would not have fallen into the pit, but for the sound of the guy digging. Whether forward or backward. And then the other view is that, well, forward means it fell into the pit because it was startled. The other is fell backward just simply means it fell near the pit because of the sound of the guy digging in the pit. Okay, so Rav says the term forward means literally forward and the term backward means literally backward. And both this and that refer to where the ox fell into the pit itself. But nevertheless, if it fell backward, he is exempt. Now we're on 53a. So the Gemara notes, Rav conforms to his line of reasoning. As Rav says, damage classified as pit, for which the Torah obligates him to pay, is referring specifically to damage caused by the pit's lethal fumes. Now, they don't mean necessarily that this is, as I've discussed before, like the pit is found in an area where methane or sulfur gas is literally coming out of the ground. What it could simply mean is that it's the kind of pit where if you fall into it, you're going to be wedged in and there's a lack of air, a lack of oxygen, and you'll end up suffocating in there, right? So it's not that necessarily the impact with the ground is what kills you when you fall into the pit, but rather by being stuck in the pit, you end up running out of air, and that is what kills you, right? So Rav is conforming to his own line of reasoning because Rav says that damage classified as pit, the kind for which the Torah obligates the owner of the pit to pay, is referring specifically to damage caused by the pit's fumes, such as if an animal suffocates inside it, but not to the damage caused by the impact of hitting the ground. Right? So just because you fell from a low height doesn't mean that that's the kind of damage or the death of your animal that creates liability for the one who dug the pit. It's really just that you were trapped in the pit, and that by being in the pit for a long enough time, that killed you. That's what the Torah was talking about. That's what Rav says. Shmuel is going to disagree, and the law follows Shmuel in this. And Shmuel says if the ox fell into the pit, whether it fell forward or whether it fell backward, he is liable. And the Gemara notes, and Shmuel conforms to his line of reasoning. As Shmuel says, with regard to damage classified as pit, the Torah holds one liable for damage caused by its fumes, and all the more so for damage resulting from the impact of the fall. So the Gemara asks, but according to Shmuel, what are the circumstances concerning which the Mishna stated that if the ox fell backward into the pit due to the sound of the digging, that one is exempt? And the Gemara answers, this applies, for example, where the ox stumbled on the pit and then fell behind the pit. And it was not injured inside the pit, it was injured outside the pit. So that's what Shmuel says it means. Our Mishnah means when it says if he stumbled backward, then he is not the one digging is not liable. Now, I think we just take a step back for a second. It seems to me, as we've been going through this, that there's a kind of general philosophy which we keep finding, which is something like this. The Torah creates liabilities for people who do certain kinds of actions that end up hurting others, right? Whether the animals of others or actual other people. And so the Torah creates liabilities. And then the sages will interpret when we apply the liability, what kind of liability, how we measure the liability, what sorts of damages are included, which kinds are not. But what the sages are not doing is passing one law after another over the centuries in order to get elected to their position, in order to placate an electorate, right? The Talmud is vast. There's no question about that. But when you look at the tort law, the civil laws that we're talking about here, the sages are not quick to create new kinds of liability. They're not saying, here's a special interest group. I want to get elected, so let me create a law that's going to appeal to that special interest group and I can run on it in the current election. Right? It's not like that. It's not that kind of legal system. What the sages are saying is, okay, the Torah created certain liabilities. If we can find a justification in the Torah to extend that liability and that kind of damage to a situation which is similar to the situation that's being talked about here, maybe we can extend it if the situation is similar enough. But if it's not, we're not going to extend it. And the sages did not create an overly litigious society, right? They're not coming with the assumption that, well, if someone got hurt, somebody must be to blame and somebody owes a bunch of money, hire lawyers, let's get the tort system fired up. They don't do that. So you can see that they will extend the law, they will create damages in certain situations, but they're quite reticent to extend into new areas. And that's why sometimes it feels like, well, they're really being picky, and it seems like, well, somebody got hurt. Like somebody should owe them. Some poor person got hurt and some rich guy owns the hole and he should pay. No, it's not like that, right? We're not going to extend, the heavy hand of the justice system, as it were, unless there's a really strong reason to do that, right? So you see that they're not creating an overly litigious system. They're not creating litigation situations unless they feel that they have to. Okay. Where am I? So the Gemara, we just said that. Okay, so the sages raised an objection to the opinion of Rav, right? So Rav says that there's going to be liability if you fall forward into the pit, but not if you fall backward into the pit. Shmuel is saying if you fall in the pit, there's liability. If you fall outside the pit, then there's not liability. So now we're talking about Rav. So the sages raised an objection to the opinion of Rav from a Brisa. Now, with regard to an animal that fell into a pit, whether it fell in forward or whether it fell in backward, he is liable. That sounds like Shmuel. And that Baraisa constitutes a conclusive refutation of Rav. So Rav Chisda said an explanation of how Rav's opinion could even accord with this Baraisa. He would say, Rav concedes in the case of a pit on his own property that a person is liable even if the animal fell backward, because the owner of the animal can say to the owner of the pit, whichever way you look at it, you are liable. If my animal died due to the lethal fumes, these are your lethal fumes. If he died on account of the impact, this is the impact of your land and not the impact of land in the public domain, which is the typical case of a pit. And now if you think about it, what are we talking about? If the animal trespasses on my land without my permission and falls in my pit, am I liable? No, I am not. We talked a little bit about the attractive nuisance doctrine, but that's not going to apply in the standard case. So if his animal is trespassing on my land, falls in the pit, no liability. But if I give the animal permission to be on my land and it gets hurt while it's there, we've seen that whether it's a pit or not, I'm going to have liability if it gets hurt while it's on my land. It almost doesn't matter that it's a pit. Okay, he happened to get hurt because it was a pit. But since he was on my land with my permission, so now I have responsibility unless I carve out that I don't have responsibility. Unless I say explicitly, you want to come on my land? You take all responsibility for anything that happens to your animal while it's there. If I don't say that, then I am responsible as the owner of the property. So they're saying, so maybe that's what Rav meant. So where am I? So Rabbah said that this is how the Baraisa should be explained according to Rav. Here we are dealing with where the animal tumbled, i.e. where it began to fall on its face, and afterward it tumbled and continued to fall on its back. And in this case, he is liable because the fumes, which were effective in injuring the animal, were also effective in killing it. Rav Yosef said, here in this Baraisa, we are dealing with damage to the pit that is caused by the ox. He's totally reversed the legal situation. It's not that the ox got hurt by the pit, and so the owner of the pit owes damages to the owner of the ox, but rather the ox came onto my land, right? It's my pit. It fell in my pit, and it died there, and it fouled the water in my pit. Let's say my pit was a cistern. Oh, now if an animal dies in my cistern, it's going to ruin the water in my well. That's a big deal. Right, so Rav Yosef says here in the Baraisa, we're dealing with damage to the pit that is caused by the ox. And what is the damage? The damage is that it contaminated the water in the pit, in which case the Baraisa states that it makes no difference if the animal fell forward, it makes no difference if it fell backward, since the owner of the ox is liable either way, presumably because either it trespassed on my land or it came on my land with the express proviso that he's responsible for any damage to his animal or caused by his animal. So Rav Hanania taught a baraisa in support of the opinion of Rav. The verse states, with regard to damage caused by a pit to an animal, and an ox or donkey fall therein, this is Exodus 21:33, which is interpreted to mean that one is not liable unless the animal falls in the usual manner of falling. So from here, the sages stated that if it fell forward due to the sound of the digging, he is liable. But if it fell backward due to the sound of the digging, he is exempt. And both this case and that case refer to damage by a pit. And so somehow what they're saying is backing up into the pit is somehow not foreseeable, and it's not something that the owner of the pit is going to be liable for, whereas just tumbling into the pit because it wasn't visible and the animal just didn't see it and fell in, that is the normal manner of falling in. It is foreseeable, and if the pit was located in such a place and uncovered in such a way that the animal ended up getting hurt because of it, then the owner is liable. Now, the master said in our Mishnah, if it fell forward due to the sound of digging, the owner of the pit is liable. And the Gemara asks, but why is this so? Let us say that it is the sound of the digger that caused the animal to fall, and not the pit itself. Okay, he was digging a pit, but he could have been doing anything, right? He could have been just transferring dirt from a mound onto a wagon. The sound of the digging is what caused the animal to stumble and fall. It wasn't the pit itself that hurt the animal. So the Gemara answers that Rav Shimi bar Ashi said, in accordance with whose opinion is this? It is in accordance with the opinion of Rabbi Nassim, who says the owner of the pit causes the damage by his digging, and anywhere that it is not possible to collect payment from this one who caused the fall, i.e. the digger, payment is collected from that one, i.e. the owner of the pit. And this is because in any event, he bears responsibility for the hazard that he created. So now we're looking at what if there's a situation where a guy hired another guy to dig a permissible pit, and then the pit ended up in the public domain. So we're going to sort of massage the circumstances so that it conforms to the legal question. And basically what you have is the owner of the pit on the one hand, that's the hazard. On the other hand, there's the sound of the digging, which could also contribute to the ox getting injured. Now, one who leaves a pit in the public domain is liable if an animal falls into it. One who startles an animal and gets hurt, maybe he's liable, maybe he's not. If we assume that he is liable, then what they're looking for is a kind of a partnership in the liability, like co-defendants, of both the digger and the owner. So as it is taught in a baraisa, with regard to an ox that pushed another ox into a pit. So the owner of the first ox is liable, and the owner of the pit is exempt. But Rabbi Nassim says the owner of the first ox, the one that pushed the other ox into a pit, he pays half the amount of the damages, and the owner of the pit pays the other half of the damages, right? Because it's like there was a partnership in creating the injury. My ox pushed Reuven's ox into Shimon's pit. Okay, so my ox carries part of the blame, and Shimon's pit carries part of the blame. So Reuven can sue both me and Shimon. Now the Gemara clarifies Rabbi Nassim's opinion, but isn't it taught in a baraisa that Rabbi Nassim says, if an ox pushed another ox into a pit, the owner of the pit pays 3/4, and the owner of the first ox pays 1/4. So the Gemara resolves the contradiction. La kasha, this is not difficult, as this second baraisa is referring to an innocuous ox that pushed the second ox. Therefore, the owner of the first ox that caused the damage is liable for only half the damages to the injured ox, right? Because his ox was an innocuous ox that injured, the injured ox. And therefore, he's only the most he would have to pay is half the damages. All right, so if an ox pushed another ox into a pit, the owner of the pit pays 3/4, and the owner of the first ox pays 1/4. And this is because we're referring to an innocuous ox that pushed the second ox. Therefore, the owner of the ox that caused damage pays only 1/4 of the cost of the damage, which is half of the half for which he would otherwise be responsible. By contrast, that other baraisa is referring to a forewarned ox that pushed a second ox. Consequently, the owner of the forewarned ox pays the full amount for which he is responsible, which in this case is only half the damages because he has a partner as a fellow defendant, which is the owner of the pit. So the Gemara asks, and with regard to an innocuous ox, what does Rabbi Nassan hold as to why this person pays 1/4 and the owner of the pit pays 3/4? If he holds that this one, i.e. the ox, performed all the damage, and the other, the pit, performed all the damage, then he should have ruled that this one pays half and that one pays half, since they are both fully responsible. Although the ox was innocuous, the owner is still liable to pay half the cost of the damage, as that is the liability incurred for an act of damaging by an innocuous ox, right? So this is goring. So if my innocuous ox, which has no history of goring, gores somebody else's animal and injures it, whatever damage it caused, I have to pay half that value because my ox is innocuous. If my ox was forewarned, has a history of doing this, and I've been told that, and my ox gores someone's animal, then whatever the amount of damages that the ox did, I'm liable for all of it. And if Rabbi Nassan holds that this one, i.e. the owner of the ox, performed half the damage, and that one, i.e. the owner of the pit, performed half the damage, then the owner of the pit should pay half of the amount for which he is responsible, i.e. half the cost of the damage. And the owner of the innocuous ox should pay only 1/4, which is half the amount for which he is responsible. As for the other remaining quarter, the injured party has no recourse to claim it. He loses it. Why then does Rabbi Nassan hold that the owner of the pit pays for 3/4 of the damage? So Rabbi Nassan is a judge, and he has plumbed the full depths of the halacha, of the laws. He didn't come to this opinion lightly. Actually, he holds that this one performed all the damage and that one performed all the damage, right? In other words, both the owner of the pit and the owner of the ox can be understood to have created all of the damage. Yes, one pushed the ox into the pit, but if one of those guys was not available, we could go for the full amount that is possible to collect from either one of the partners. And as for your difficulty, that this one should pay half and that one should pay half, this is not difficult. The owner of the ox pays only 1/4 because the owner of the ox can say to the owner of the pit, how did my partnership with you in this situation help me? Even if my ox caused all of the damage and none of the damage was caused by the pit, I would be required to pay only half the cost of the damage. Therefore, since we are partners in this situation, I should pay half of what I would have paid otherwise, which is 1/4. And you should pay the other half of what I should have paid in addition to your share, since you would have had to pay full damages, right? You're getting off easy by only having to pay 3/4. So the Gemara adds, if you wish, say instead a different explanation. Actually, Rabbi Nassan maintains that this one performed half the damage and that one performed half the damage. And as for your difficulty with the fact that the owner of the pit should pay half and the owner of the ox should pay 1/4, and the injured party loses the other remaining quarter, that is not difficult. This is because the owner of the ox that was killed can say to the owner of the pit, I found my ox in your pit. Consequently, I am assuming that you killed it. Therefore, concerning that portion of the payment that I can receive from the other one, meaning the owner of the damaging ox, I will receive it. Concerning that portion I am unable to receive from the other individual, I will receive it from you. So on the same subject, Rava says, if one left a stone at the opening of a pit belonging to another person, and an ox came and stumbled on it and fell into the pit, so we have arrived at the dispute between Rabbi Nassan and the rabbis, the majority, concerning the division of responsibility between them. And the Gemara asks, well, isn't this obvious? Since what is the difference between whether the ox fell into the pit due to another ox pushing it or due to the stone that somebody left in the public domain where he shouldn't have? And the Gemara answers, this ruling needed to be stated explicitly, lest you say that only there the owner of the pit can say to the owner of the ox who was responsible for the damage, if not for my pit, your ox would have killed the second ox anyway, in which case my pit was not the cause of the damage. But here the owner of the stone can say to the owner of the pit, if not for your pit, what would my stone have done? If the ox would have stumbled on it, he would have simply fallen and gotten up, and I should be exempt. Therefore, Rava teaches us that this claim is not a valid one because the owner of the pit can say in response to the owner of the stone, if not for your stone, the ox would not have fallen in my pit in the first place. New subject as we move into page 53b. It was stated there is a dispute with regard to a case of an ordinary innocuous ox and a disqualified consecrated ox that gored another ox together. All right, let's unpack that for a second. An ordinary innocuous ox. It's a simple ox, plain ox, that has no history of goring. If it gores somebody's animal, then we assess how much the damage was, and the owner of the innocuous ox has to pay half that amount. What about a consecrated ox, a disqualified consecrated ox? Well, if it's a consecrated ox, right, nobody can benefit from it. We know that. And the temple is not going to have to pay damages when a consecrated ox gores another. Why disqualified? Okay, so disqualified means it cannot be offered on the altar when the temple is standing, but neither does it go back into the herd, right? So it's got special special circumstances surrounding the disqualified consecrated ox. So now we have this combination of an ordinary innocuous ox and a disqualified consecrated ox that gored a third ox, and they did it together. So what is this case of an ox that was consecrated and disqualified? What are we talking about? It is a firstborn ox that became blemished and was consequently disqualified as an offering. Nevertheless, its initial consecration remains, and therefore it may not be redeemed. Consequently, the priest in possession of it is not liable to pay damages since it is not classified as the ox of another, as its the ox of a person, as its status is not that of a non-sacred ox that belongs to an owner. Given this background, what is the liability of the owner of the non-sacred ox that gored together with it? And Abaye says he pays half the cost of the damage, whereas Ravina says he pays 1/4 of the cost of the damage. So let's analyze. The Gemara explains the dispute. Both this one, Abaye, and that one, Ravina, refer to a case where the ordinary ox was innocuous. And this opinion stated by Ravina is in accordance with the opinion of the rabbis that each party is responsible for only half the damage. Since the non-sacred ox was innocuous, its owner pays half the cost of the damage for which he is responsible, which is half of a half, so therefore 1/4 of the total. And that opinion stated by Abaye is in accordance with the opinion of Rabbi Nassan in his dispute with the rabbis, that each party in turn is responsible for all the damage. Consequently, since the non-sacred ox is innocuous, its owner pays half the total amount. And this is not so, it's not so dissimilar from types of lawsuits that occur today, right? So, for example, there's a movie, I guess it opened today. I look forward to seeing it, called The Boys in the Boat, which is about the 1936 U.S. national rowing team. Back then, colleges became Olympic teams when they won the qualifiers. And this was the University of Washington. And what was great about it, it was like, rowing sounds like a very elitist sport, but these were very much working class kids who could barely get by and ended up, becoming this national team and then going to the Olympics, in Germany, in Berlin, right, 1936. A very colorful story. The book was great. So I look forward to reading this. I mention this only because when I was in college, I was a rower. I was on the rowing team, and we were on the river once and we were training for a particular race. We're actually going to nationals, and one most of the boats were 8s, but we also were taking 4s and pairs that time. And my friend Gordy and I had a boat, right? So it was the two of us rowing a boat. A pair is difficult because you don't have the coxswain steering the boat for you. You guys have to steer it. And we did steer it properly. We might have been a little bit toward the middle of the river, but we weren't on the wrong side of the river. and there was a single sculler coming the other way. He was on the wrong side of the river. And we ran into him. Now, because we're in a pair, he's in a single, our boat had a longer bow than his. The result of that is that the tip of our boat speared him, like it stabbed him in the back, at speed. I mean, he was really injured by this. It could have been much worse. The guy wasn't paralyzed or anything, thank God, but he was really injured. He got a hole in his back. Our coach came along, picked him up, the whole thing. There was a lawsuit. And really what was wrong with the reason he had an action at all is because our boat didn't have a bow ball on it. It didn't have a rubber ball on the tip that might have, lessened his injury if it had been there. So who were the named parties in the lawsuit? Me, Gordy, our coach, and the university, right? Now, who were they really suing? The university. And that's who took over the lawsuit and defended it. And, we never had to appear. We never heard about it again. Presumably they settled. It was all done. We were just college kids. But you could say, well, in that situation, right, they could argue that we were in the wrong part of the river. I remember we were in the right part of the river, but we'd have to prove that, or they would have to prove we were in the wrong part of the river. But we were the guys rowing the boat. They could say that the coach is responsible for putting us out there in a boat without a bow ball on it. And of course, the university, with its massive endowment and insurance policy, that's who they were really suing. But, right, if the university, let's say, went bankrupt and disappeared, so where are they going to get their damages from? So then they would, look to us as individuals or the coach. And so this idea about, sort of co-defendants or joint defendants in a lawsuit when somebody gets hurt, and you're going to sort of, over-litigate in that sense, over-sue, bring in more parties just so that you can be sure to get paid, as it were. And what the rabbis are arguing about is, well, when you can say that there's joint responsibility for what happened, are each of the individual parties that are being sued responsible for the whole amount of the damages if the other participants, if the other defendants die or disappear or go away or go out of business, if no money can be gotten out of them, are you able to get the full amount from the parties that are available? Or do we say that since there was joint responsibility, the most you can get from any one party is his proportionate share of the total damages, right? That's the question that they're arguing about. So let's continue. Where was I? Right. And that opinion stated by Abaye is in accordance with the opinion of Rabbi Nassan that each party in turn is responsible for all the damage, right? You could go to any one of those individuals and get the whole damages from the individual if the other individuals were not around. Consequently, since the non-sacred ox is innocuous, the owner pays half the total amount because that's the most he'd have to pay anyway. Now, if you, not because it's half of the parties that were responsible, but because the innocuous ox only leads to half payment of the total damages. The rabbis would say, well, the most that he would have to pay is half, but it's because there are multiple people responsible, then the owner of the innocuous ox only has to pay 1/4. Rabbi Nassan would say, no, each party could be held liable for the whole amount because it's an innocuous ox. He only pays half, but he doesn't pay 1/4, he pays half. So if you wish, or he at least would be on the hook for a whole half. So if you wish, say instead that there is no dispute and that both this one, Abaye, and that one, Ravina, state their opinions in accordance with the opinion of the rabbis. So who say that you do divide the total pot and any one defendant is only going to be responsible for his proportionate share. So according to this view, this one, Ravina, is referring to where the non-sacred ox is innocuous, and so its owner pays half of a half. And that one, Abaye, is referring to where the non-sacred ox is a forewarned ox, so its owner pays his entire share, which would be half the total damages because we're going according to the rabbis. If it was according to Rabbi Nassan, the owner of a forewarned ox that pushed another ox into a pit would nevertheless be liable for the whole damages if the owner of the pit was not available to partner with him in paying off the damages. There are those who say that there was another version of this dispute. Abaye says that he pays half the cost of the damage, and Ravina says he pays the full cost of the damage. And the Gemara explains the reasoning. Both this one and that one are referring to where the ox was a forewarned ox. So this one, Abaye holds in accordance with the opinion of the rabbis that each one is responsible for half the damage. And so he pays his share of half the total cost of the damage. And that one, Ravina, holds in accordance with the opinion of Rabbi Nassan that each one is fully responsible for the damage. And when one perpetrator of the damage is exempt from payment, because it was a consecrated ox, such as this case, then the entire amount is collected from the other. And if you wish, say instead that there is no dispute and that both this one and that one hold in accordance with the opinion of Rabbi Nassan. This one, Ravina, is referring to where the ox was forewarned and the owner pays the full cost of the damage. And that one, Abaye, is referring to an innocuous ox for which only half the cost of the damage is paid. And now we go to a slightly different subject. Rava says, with regard to an ox and a person that push a person or animal into a pit, then, concerning the damage that they caused, they, i.e. the man who pushed the person or animal, the owner of the ox, and the owner of the pit are all liable to pay the indemnity of damage, right? So what have we got? There's a person who partners with an ox to push a different animal into a pit. So we see that there are three causes of the injury of the animal that ended up inside the pit. One is the animal that pushed. The second is the human who pushed. And the third is the owner of the pit into which the animal was pushed, where it became injured. So they are all liable to pay. And now we're not just talking about the damage, we're talking about the indemnity. Right, the indemnity, which is something different. Now, concerning the four additional types of indemnity, which are loss of livelihood, pain, medical costs, and humiliation, and also with regard to the compensation for miscarried offspring, the person who pushed a person, let's say the victim was a person who got pushed into the pit, so the human who pushed the other human is going to be liable for those four kinds of damage, right? Not just the damage to the person, but also pain, loss of livelihood, medical costs, etc. Right? So the person who pushed is liable, and the owner of the ox and the owner of the pit are both exempt. Why? Because the Torah did not impose any obligation on the owner of an animal that damaged a person or the owner of a pit in which a person was damaged. The Torah did not impose the liability to pay those indemnities on those people. The indemnity only applies when a human hurts another human. With regard to the payment of ransom, right? So remember that the ransom, that comes up when a person's ox kills a human, right? So when an ox kills a human, the ox, as long as the ox did it with some kind of malice, then the owner of the ox, so the ox is going to be stoned, it's going to be killed because it killed a human, and its owner has to pay not only damages to the person, to the family, right, of the person who was killed, but also the ransom, which is a different amount of money and is paid according to the value of the person. And it's understood to be an atonement for the owner of the ox that he didn't sufficiently safeguard his ox, and he doesn't want to carry that, that transgression around with him. So he has to pay this ransom. That's what the ransom is. So where do we go? So with regard to the payment of ransom, if it was a person who was pushed and killed, and also concerning the 30 shekels paid for a Canaanite slave who was killed, so in that payment, the owner of the ox is liable, and the man who did the pushing and the owner of the pit are exempt, because this payment of ransom only applies by Torah law where an ox kills a person. It's not used when a human kills another human, nor when a human falls into someone's pit and dies. With regard to vessels and a disqualified consecrated ox that fell into the pit, the man who did the pushing and the owner of the ox are liable, and the owner of the pit is exempt. We've already seen that when an animal falls into your pit, you're liable for that, but the stuff on the animal, the saddlebags, the utensils, whatever accoutrements were on the animal, if those are harmed when the animal falls in, the owner of the pit is not liable for that because the Torah law did not extend that liability, and the rabbis don't create a liability where the Torah didn't. So Rava explains what is the reason that the owner of the pit is exempt from liability for damage caused to a disqualified consecrated ox. Since the verse states with regard to a pit, and the carcass shall be for him, Exodus 21:34. And it teaches that the obligation to pay damages is imposed only on the one to whom the carcass subsequently belongs, thereby excluding this case of a disqualified consecrated ox where the carcass does not belong to him. In this case, it is prohibited to sell the carcass because it was a consecrated ox, and the owner of the pit cannot derive benefit from it, and it no longer belongs to anyone. So the conditions written in the verse are not in effect. And the Gemara asks, is this to say that this matter was obvious to Rava? Is it not a dilemma that was already raised by Rava? As Rava asked, what is the law with regard to a disqualified consecrated ox that fell into a pit? Is this verse, and the carcass shall be for him, referring to the one to whom the carcass belongs, i.e. the owner of the pit, and excluding this case where the carcass does not belong to him, and therefore the owner is exempt from paying for it? Or perhaps the verse, and the carcass shall be for him, comes to teach that the owner of the animal attends to, i.e. retains ownership of the carcass, and the perpetrator of the damage pays him the difference. And the Gemara answers, initially Rava was in doubt about the matter, but after he raised the dilemma, he then resolved it himself and concluded that the verse imposes liability for the cost of damage only on a person to whom the carcass belongs, excluding the case of a disqualified consecrated ox. I'm almost done. If you got questions or comments, please get them in. So the Gemara asks, rather, from where does he derive the law that the owner attends to the animal carcass? And the Gemara answers, he derives it from the verse, and the carcass shall be for him, in Exodus 21:36, which is stated with regard to the general category of damage by an ox. And the Gemara asks further, what did you see to determine that? What did you see to determine that from the verse, and the carcass shall be for him, stated with regard to the general category of ox, that you derive from it the law that the owner of the dead ox attends to the carcass? And from the verse, and the carcass belongs to him, which was stated with regard to the category of pit, you derive from it the law that only the one to whom the carcass belongs pays damages? Why can't I reverse the derivations from each verse and say the opposite? And the Gemara answers, it is reasonable that the exemption applies to the verse stated with regard to pit, since the Torah also exempts one from paying damage classified as pit caused to vessels that fall into it and break. So the Gemara challenges this answer. On the contrary, one could claim that the exemption applies to the verse, the exemption where there's not going to be damages paid by the owner of the pit if the animal that falls into his pit is a consecrated ox, right? Because there's a disqualified consecrated ox. If it was a consecrated ox that's still qualified, he'd owe that money to the temple. But since it was a disqualified consecrated ox, it's as if no one owns it. And that's why the owner is going to be exempt from having to pay damages to anyone, because who would he pay it to? So the Gemara challenges this answer. On the contrary, one could claim that the exemption applies to the verse stated with regard to ox, since the Torah also exempted the owner from half the cost of the damage in the case of an innocuous ox. And the Gemara responds, in any event, we do not find that the owner of the ox is exempt from compensation for the full cost of damage. By contrast, with regard to pit, there are certain items for which a person is not liable at all, namely utensils that fall in along with the animal. Therefore, it is logical to conclude that the Torah is more lenient in cases of pit than it is in cases of ox, right? The general category of ox includes goring, trampling, and eating. And so we're saying that the pit is, generally speaking, a more lenient body of law than the law of one who owns an ox that hurts other people's animal or humans. That's what I've got for us today. Let's take a few questions. Okay, Nina says there were a lot of comments, so we don't have so much time. We're just going to take one per person of the one she passed over to me. Says Sharon, who is liable for Joseph being in the pit that we just read about in these last few Torah portions? His brothers who placed him in there, the people who left it open and exposed, or both? What a great question. So the owner of the pit would, I'm sure, say, listen, nobody ever ended up in that pit. The only reason that, by accident, right, the only reason that this kid ended up in that pit is because his brothers turned on him and threw him in the pit. Now that they wanted a pit to throw him into, they uncovered my pit. My pit was covered. That's, I'm sure, what they could say. If, in fact, right, they found the pit open, and that, I guess you could put it sort of like if somebody leaves a gun lying around on the street and someone picks it up and shoots, another individual. So who's going to be liable for that? I mean, obviously the guy who shot the gun at a person is to blame, has criminal liability. He's the one that did the shooting. But hey, he never would have had that gun in his hand if someone hadn't left it lying around. So it's a good question. I'm not sure the answer there. Tom, was there any record of pre-sages interpreting the Torah? I realized there was very little written down, but was there any oral tradition of debates and rulings in the centuries between Moses ceding power to Joshua and the era of the Tanaim? Absolutely. First of all, we have the teachings that are like Moshe Sinai, right? So there were some oral teachings that were given to Moses at Mount Sinai. And those were passed down orally, right? From Moses to Joshua, from Joshua to the elders, etc. We also have, this idea that the patriarchs knew the Torah. They didn't have the written Torah in their possession, but there were many laws that ended up being in the Torah later that were already known to them. And for example, there's a midrash that says, and Rashi holds by it, that if you sort of measure, if you look at the number of years that Jacob was away after he fled from Esau who wanted to kill him, went to Lavan, ended up working, for his uncle 20 years in order to marry first Rachel, and then he got Leah, but so he worked an additional 7 years for Leah, 14 years plus 6 more to build up his own wealth. And so that adds up to 20, but I think he was away for, I think it was 34 years. I forget the exact number. And so the sages understand that where was he for the missing 14 years? He was studying in the yeshiva of Shem and Aver, right? So Shem I think Shem is a son of Noah and Aver is his son. So there was already a wisdom tradition that went back to Noah, and that, and that included all kinds of teachings, and then it was augmented by Abraham, to whom the mitzvah of circumcision was given. But there was a lot of other kind of Torah rulings. Now, do we have a record, of debates and discussions and, this prophet said this and that prophet said that? Not so much. Not so much in the biblical period, the way we do in the post-biblical Talmudic period, the Mishnaic period and then the Gemara period. But there definitely are some rulings and some traditions that go back, and I'm the wrong guy. There's definitely much bigger experts than me to answer this question in a better way. So that's as much as I can offer. Lucy, is pushing considered the same thing as goring? Because if not, the concept of forewarned does not seem to apply. I think what we've seen is that pushing can be considered like goring if it's not incidental pushing, right? Where the animal just kind of like, rubs its hide against a wall. It's like scratching an itch. So that's more similar to eating, and then it happens to do damage. But if the animal pushes a person, let's say an ox that doesn't have horns, its horns have been removed or it just never had horns, but it uses its head to push. So now it's doing that, with some malice, in the sense that, why is the ox doing that? The ox has some kind of emotion that it is expressing, right, by pushing the person. It's annoyed, it's bothered, whatever it is. And so if it now creates a pattern of pushing people and hurting them, the owner could become forewarned for that, and it would be in the same as the category of goring. That was Lucy. Joe, whoever is in the pit digging away should be badly injured, could be badly injured, even killed. Is his life worth compensation? Or, since he created the problem, is it one of those issues where there is no compensation because he was at fault? Right, so great question. I mean, if he's digging in the public domain where he shouldn't be digging to begin with, and that if he left his pit there, he created a hazard, I would think that if an animal falls in on him and hurts him, he's out of luck, or his family's out of luck, let's say, if he's killed. On the other hand, if he's digging on his property, or let's say he's a digger who's digging on private property, or he's told that the property is private, so he's not doing anything wrong, and an ox falls on him. Well, if it's not his pit, you certainly could sue the owner of the pit who made this guy dig, I would think. Although there is no agency for transgression. So, if he was doing a circumstance beyond his control, he didn't know. But if he knew that he was digging a pit in the public domain, it wouldn't matter that somebody told him to do it. It would still be illegal. So I guess the answer to your question is it depends on the circumstances. We would also ask, what was the ox doing there that it fell into the pit? Was there any kind of negligence on the part of the owner of that ox? Is this an ox that is forewarned for falling into pits? We've actually seen that. Where it falls into pits where most animals wouldn't, but this particular ox does. So there's other factors. And finally, Joseph says, what if somebody's boss told the person to leave a pit uncovered, right? So that's the same question. If it's clear that any reasonable person would say, wait a minute, leaving that pit uncovered creates a hazard, then I was following orders does not work, right? Because a reasonable person can see that leaving that pit uncovered, it creates a hazard that people could get hurt. And so he violated the Torah, the negative commandment, do not leave a pit uncovered. So he should have just covered it. And then if the boss wanted it uncovered, then the boss can uncover it. If this guy says, you're going to lose your job, which you can't afford to lose if you don't cover that pit, okay. But if somebody says you're going to lose your job unless you commit murder, you're not going to commit murder. So it's just one of those things where there is no agency for transgression. That's what I've got for us today. With God's help, we'll be together again tomorrow, Tuesday at the regular time, 6 p.m. Pacific. Wednesday, we're going to a wedding. So most likely class is going to be at noon, right? So class will be at noon on Wednesday, but we'll make an announcement about that. But tomorrow, regular time, 6 p.m. Pacific.